May I be permitted to mention this matter? Lordship, a direction was given to file affidavit in opposition. Lordship, the asked file advocate on record could not be traced. That's why, my lord, the affidavit could not be affirmed. And my lord was pleased to, my lord, hear the matter. And my lord, the on 11th of August, the order was passed, Lordship, wherein, my lord, my affidavit in opposition's right has been, my lord, exhausted. My lord, kindly fixes up, my lord, tomorrow to be mentioned. My lord, the difficulty is, my lord,
Application.
my lord, the
No to be mentioned. Move an application.
my lord, I shall, my lord, I shall, my lord, I shall, my lord, certainly, my lord.
State all the grounds. Move an application. Seek condonation.
But my lord, my lord, unless my lord, I can file my vakalatnam, I cannot, my lord, proceed with the matter, my lord.
File your application whichever way you want to file.
My lord, I cannot file, my lord, unless I have a vakalatnama.
GS প্রত্যেক GA তে वकालतनामा দেয় every GA consider you know
You have to file the वकालतनामा in the GS.
malada commercial division section 11 million matter millet it was given the in the returnable form it was, the date was given for today. It has not listed millet, kindly listed any day commercial division লিখে দিয়েছি
Lordship, may I have your Lordship's leave to mention matter number 92, where for the award holder, our interlocutory application has been tagged with the main execution application and is appearing under execution cases today. If your Lordship kindly allows this to appear under new chamber applications. 92 has been incorrectly tagged.
So this is your EC, right?
The main proceeding, I appear for the respondent. The main proceeding is the execution case. The interlocutory application will principally have the same prayers as that of the execution case.
Then why should I allow it as well?
I'm for the respondent. I'm opposing the mention.
What exactly is there? What is your application?
Lordship, it is for the attachment of the bank accounts of the award debtors. On the previous occasions, they had not marked any appearance. And
34, what about 34?
At 34, my lord, I'm carrying the order. Today, the matter has been fixed before the learned Asansol Commercial Court. The matter is fixed on today and tomorrow, a final hearing and filing of the written of arguments. It's listed. Well, I'm carrying a copy of the cause
No
list
36 file, Millard.
No, we've not.
34 is pending. Millard. There is no stay.
The matter is
But
there.
that's
Tomorrow,
right,
it's
but
supposed to
today
be.
it's fixed for hearing and final written notes. So your 34 is getting decided.
It's been pending for the last 2-3 years, Millard. We are appearing
this
for
is the
Millard
order.
authority, Millard.
Yeah.
And Millard, we have taken out an interim application in the execution, Millard. Well, perhaps not, it has got wrongly tagged with the main execution application. I'm only praying, Millard, let the interlocutory application come under the heading new chamber application.
You appear for the steel authority.
Still authority. But she's my junior, but it's her maiden appearance, so I will not talk.
You should encourage. That's all right. But there's no point listing it. Let it come. The 34 is being decided.
Millard, this
What is the
34, Millard, may I, Millard, I have it. 34 is pending for the last 2 years, Millard. And
Yes.
moreover, they have not filed any 36, Millard, and there is no stay therefore. Millard, Lordship, kindly, Millard, direct the interlocutory application to come up. If your Lordship feels that no order needs to be passed, then your Lordship may decide that next Thursday, if your Lordship. This is Steel Authority of India Limited, not a government organization. Not 8
When is
crores
the next date in this?
14th.
8 crores are due, Millard.
Tomorrow.
No
Tomorrow.
stay.
My only prayer was, Millard, let
Mention
it
it next
come out.
week.
Let it be discussed.
Mention it next week.
Grateful, Millard. I shall come back on Monday. Grateful.
Just let me know what happens on
Yes.
the
Lordship, I shall.
Definitely. Most grateful.
Lordship, I think to mention a matter which is,
Yes, sir.
I want to mention a matter. It is listed as item number 126 in today's 3 p.m. list. But
Yes.
we have been informed that there is a resolution for the honorable judges to rise up by the bar. So I seeks that if it could be upgraded or taken up earlier.
Can't be.
It's a 34.
Can't be upgraded today. Sorry.
We'll wait.
Yes.
Do you mention item number 1?
My lord, this matter has been settled between the parties. I'm praying for withdrawal. Finally, vacate all interim orders.
Learned counsel for the petitioner states that the matter has been
This is the instruction mail.
She wishes to withdraw the present petition. The same is dismissed as withdrawn. Interim order, if any, stands vacated. Any warrant?
No. Vacate all interim orders.
All interim.
I already submitted the instruction mail record.
Take line order. Instructions received from the client to withdraw the present petition is taken to court. Only one, right?
Only one.
Yes.
Nitya, application item number 2.
But I appeal for the petitioner.
Some settlement was going on. What happened?
Not settlement. May I tell you, Lordship, the settlement was this one. There was a arbitration proceeding, Lord.
Yes.
Retired judge of this court has been appointed as arbitrator. He has passed an award. Then they challenged the award in section 34. That was dismissed for default. I filed an application for execution. Then they got it when the execution was pending. They got it restored. So naturally, that execution application dismissed the liberty that you must proceed as and when situations arises. That liberty was given there. Now, my lord, subsequently, my lord, they called on after this 2014 Lordship knows, my lord, there was a Vivad Se Vishwas Tak scheme floated by the government. So they called on us with Cooperative Society of Engineers. We went there, all are above 80 years of age. So naturally, these old people went there. They submitted all the documents. Then it was discussed, several documents called for, then bank guarantee and everything was mooted out. Then at that point of time, a letter came in 2025 that as if this is pending, 34 is pending here, so naturally the settlement cannot be met. That was what the letter was written by them. So naturally my client subsequently filed this application for execution. Now, my lord, what it transpires, my lord, well, long years have passed in the meantime. Now they are admitting probably that there is no 34 is now pending.
No 34?
34 is no more pending. So they are now taking a plea that as if this is a barred by limitation. 12 years have gone now. So, my lord, what I'm trying to do by this application, that what this application was initially filed, that may be revived along with this execution application. So that, my lord, because I have no fault. I have tried to proceed with execution, they got it restored. All documents were disclosed, but
The reply has been filed.
no, we should file for it.
Madam,
But
may I
we have not filed.
point out certain dates, madam? The award was passed on 18th July 2007. Yes. Then my 34 application, which was filed, that was dismissed. No, madam, thereafter, they have filed execution application on 20th/7/2010. On this date, their execution application was dismissed.
Dismissed or it was
Dismissed. And my 34 application was dismissed on
dismissed on what ground?
dismissed for default.
No,
Execution application.
no, please.
May-
The
may- may-
execution
may-
was dismissed because they got the 34 restored. At that point of time, your lordship knows, not because the Supreme Court judgment also, once 34 is filed, so it's automatic stay.
Yes.
Now the Supreme Court has of course changed it, but that's a later on.
That was
Now, but in the meantime, what has happened? They got this,
It
their
was dismissed in 2010 because 34 was.
30 was pending because initially it was not dismissed. They got their default dismissed for default 34 application restored. So naturally, as Sanjeev Banerjee told me that no other way. I'm giving you liberty as and when situation so arises, you can proceed with the execution.
may give two more dates.
But that's a later.
Let him
But
give the-
1st April 2010, my section 34 application was dismissed. First time, dismissed for default on 1st April 2010. Thereafter, my lord, on 19th July 2010, my application was restored. So, my lord, that till that date and above also till 2015 I take, my lord, because that amendment was in 2015, my lord, when they. So till 2015, they have right. The matter was automatically stayed. Thereafter, it was not automatically stayed. But my execution application was second time, my lord, it was dismissed on 10th May 2011. Section 34 application was dismissed on 10th May 2011. So from 2011 to 2026, that's 15 years, my lord.
2011 to 2026.
Now they have filed a second execution application in 2026, my lord, this year.
But
So,
then
my lord, from
they will
2011
be
to-
covered by the earlier act 2011. since your 34 was dismissed, you didn't take any steps after that, 2011.
No, my lord, they called upon me that because of this Vivad Se Vishwas Tak settlement, you please file your documents. We filed there before the Metro Rail authorities.
But
There
that
were-
is no ground to take.
No, it was proposed that 75% you take it, and we agreed very well. Then they said certainly in 2025 that because 34 is pending, so will not settle it. Kindly, my lord, come to my the application, subsequent application. That's at page, my lord, 70,
Page
the
70.
first application,
Yes.
page 70. That's the letter of 30th January 2025 by the Deputy Chief Engineer, my lord. What is writing to me with reference to the above? This is to inform you that award dated 5/11/2009 has been challenged before the Honorable High Court, Calcutta, by Metro Railway bearing so-and-so number, and the matter is sub judice against so-and-so. In this connection, it is mentioned that as the matter is sub judice before the Honorable High Court, Calcutta, accordingly, at this stage, it's not prudent to take any action without order of the court. So, my lord, we searched out the record and subsequently could not find out the current records. But what my advocate record did, he found out something in 2011 that this matter has again been dismissed. 34. So that's only in 2025 we came to learn of it. Now, if your lordship will kindly look into my
There's
petition,
no occasion to revive this.
lordship,
There is no occasion to revive the present.
but that's what I'm trying to rely upon judgment. If your lordship kindly first take with my petition, now new petition, lord.
Sir, whatever it is since 2011, it is barred.
No, my
How
lord,
can you file this?
may I tell you, lordship, lord?
Even if
Supreme
you have
Court saying
for your settlement or
I
whatever,
will try to rely upon judgment of Supreme Court on this issue, lord.
show me the Supreme Court that you can revive after.
Sir, I have cited one judgment of our Honorable High Court. My lord,
If your lordship looks into this judgment, lord, this is 19.
Para
Let's see,
15 and 16.
reference. Reference.
Let him make his submission, then you make your submission.
Lord, may I hand over this judgment of the Supreme Court, Lord, 1964. Where is it? 1964 Supreme Court 1454. I'm sorry, Lord, I'll hand over my copy to an friend. If your lordship state will come to the two relevant paragraphs, Lord, paragraph 7 and 8. Previously, it was section 48 of Code of Civil Procedure, Lord. Now that 136 has been introduced after 1963 Act of the Remuneration Act, that will take into account, Lord. Paragraph 7 says, Lord, has your lordship got it, Lord?
Yes.
The result of the distance may be summarized thus. An application made after 12 years from the date of the issue would be a fresh application within the meaning of section 48 of the Code of Civil Procedure if the previous application was finally disposed of. It would also be a fresh application if it asked for a relief against parties or properties different from those proceeded against in the previous execution petition or asked for a relief substantially different from that asked for in the
This is,
earlier petition. Now, kindly paragraph 8, Lord.
sir, it
If
is distinct. Wait a minute.
Lordship.
This very paragraph which you are reading out, that can be distinguished.
But please, paragraph 8, then I will submit. I understand what your lordship is trying to say to me. In this case, as we have pointed out, the parties are substantially the same. Here also same in both the proceedings, and the decree holders are only proceeding against the properties included in the previous application. I'm only trying to realize my money. There is no case that they have. This is not payable to me. It cannot therefore be treated as a fresh application within the meaning of section 48 of the code. It is only an application to continue EP number 13 of 1939. That's exactly here I'm trying to do, Lord, which I filed originally in 2010 and which was dismissed by His Lordship, the Honorable Justice Chonji Banerjee. What is said, Lord? In such view,
This proposition is against you.
sorry, Lord.
This
To me-
proposition itself is against
No,
you.
the judgment is saying, if I understood correctly, Lord, it's entirely for your lordship to accept it or not. It says that if the property is remaining the same, party is remaining the same,
It says the properties are different.
But-
Paragraph 7, if it is asked for a
Kindly
relief
come to
against
paragraph 8,
parties
Lord.
or properties different from those proceeded against in the previous execution
Yes.
petition, or asked for a relief substantially different from that asked for in the earlier petition.
That was there in that 64 matter. Now kindly come to paragraph 8. Exactly same in our case. In this case, as we have pointed out, the parties are substantially same. Here also same. My client, this is Development Cooperative Society, and they are the Metro Railways. Sorry. Same in both the proceedings, and the decree holders are only proceeding against properties included in the previous application. This is also same, Lord. Only the amount has gone up. That was in 2010, now it's 2026. So amount has gone up. It cannot therefore be treated as a fresh application within the meaning of section 48 of the code. It is only an application to continue EP number so and so, which is pending. That's exactly, my lord. If your lordship now kindly take up Justice Banerjee's order, my lord.
So you
Yes,
read it fully, sir. Paragraph 8 also.
My lord.
And then para 9.
Oh, sure. Well, para 8, in this case, as we have pointed out, the parties are substantially the same in both the proceedings, and the decree holders are only proceeding against the properties included in the previous application. It cannot therefore be treated as a fresh application within the meaning of section 48 of the code. It is only an application to continue EP number 13 of 1939, which is pending on the file of the executing court. Then 9. That apart, the decree holders file EA number 142 of 1952 in EP number 13 of 1939, expressly asking for the reopening of the said execution petition and for proceeding with it. As we have held that the earlier execution petition is still pending on the file of the court, the executing court will be well within its rights in proceeding on the basis of the earlier execution petition, even without a new petition. But here, what has happened?
In the result, that is the reason why it was dismissed.
Hmm.
So how does this proposition help you?
But it's helping me in this sense, my lord. When this order was passed on 20th July 2010, that may place before lordship, that was not annexed in the petition. So I advise them, why have you not annexed it? So this is the new petition that I have filed now. Application in that execution application. But lordship, get it at page 9. In the G8 file color. Please Ashok Babu. First annexure A, page 9. Has this copy been served on it? I don't know. This is okay, thank you. না এক্সট্রা কপি নেই, এইটি আমাকে তো একটাই ব্রিফ দিয়েছে না, ও কোথায় চলে গেল কই কল। May I place before lordship the order that was passed. It is submitted on behalf of the parties that the setting aside application taken out by the Union of India has been restored, and as such the execution can no longer be proceeded with. So there was an embargo on me now. In such a view of the matter, EC number 142 of 20 is dismissed with the liberty to the decree holder to execute the award at the appropriate stage if so permitted. Entitled, sorry. That is exactly what I'm trying to follow.
The appropriate stage will be 2011 when the petition has been dismissed.
But subsequently what has happened, we don't know. Because they are saying to me that she's still pending. That's their letter I've shown to your lordship.
The order is there. Forget about
But that was the order 2011.
Yes, that's
Because
all.
they have got it restored or not restored, they can say it. I cannot say it. But we have tried to search out, but the records are not available here. That's what I'm told by my advocate. That's the
They are
difficulty.
making this submission that in 2011 it's been dismissed.
Now, Miller, kindly see what's their letter
34 has been decided in what happened. Was it dismissed for default again?
again. That's it.
2011. So that's it.
So they could have restored it.
They have not done anything, sir. Why are you sitting today?
No, I'm not sitting, Miller. They called
What
me
did
for
you do after that?
they called me for a settlement. That come to me,
That
submit your documents, we are ready to settle with you.
entitle you from filing a petition.
Most probably they have thought it that they are old people. If they
Just
paid us
because
money,
they are old people, they have thought it they can change the law.
no, sometimes it does
Laws have
happen.
changed because they are old
Sometimes
people.
this happens.
For old people, we should change the law.
No, but what they wrote to me, that's very important. Lord. They are writing to me.
Doesn't matter. You can get any letter written by anybody.
No, my lord.
We all know how letters are written. We go by what the record is. The record is in 2011. The petition has been dismissed. There's no execution which can be filed in 2026.
Now, if your lordship,
That's
lord,
what the law is.
now, my lord, I will lie upon a very judgment of the Supreme Court also, my lord, where the Supreme Court is saying if the money is due to the other party, the government should not take a plea of limitation. Because if the money is not due, I could have understood that very well. They're disputing, they're challenging. But it's not a fact. Because the award is now payable to me. Now, my lord, only I'm trying to show before lordship, lord, they called upon me. Kindly see, my lord, the application, this ought to have been there also. Annexer B, my lord, that's a GA, in GA, my lord, lords will find how they have proposed to me. That is in 2017. A copy of Railway Board's letter is enclosed herewith, which communicates the decision of CCEA regarding payment of 75% payout obligation to the contractor after opening an escrow account with the lead banker and furnishing a bank guarantee in the format annexed herein. You are requested to please submit a bank guarantee so and so. Normally, we wanted to know what is the amount that you are, because we have to furnish a bank guarantee. Is it X amount or X plus Y amount? So that was the correspondence going on. And ultimately, they in 2025 said that no, we are not going to sell to you because the 34 is pending. So they are saying the 34 is pending. So Ireland must have been restored in the meantime.
So you are not supposed to do anything.
No,
You go by whatever they say.
because they called upon me to pay it off. That's the reason. Lord, may I rely upon this judgment, Your Lordship. This is the judgment is naturally very old. 79 Supreme Court is directly taken from the book. It's not come up very nicely, my lord. If Your Lordship pardons me, the marking portion I can hand over to Your Lordship, Lord. It's a
Don't give
one-page
judgment
judgment.
which is not.
Say EIR 1979, Supreme Court 1144.
Don't give a judgment which I can't read.
This is little bit readable, but this judgment copied from their 79 Supreme Court 1144.
All right, these are your submissions, not else.
Only just sorry, my lord.
Yes.
Sorry. Well, I can place before Lord the paragraph that was said so. Blood paragraph 2. We do not think that this is a case where we should proceed to determine whether the claim of respondent was barred by Section 100 so and so Madras Port Trust Act. The plea of limitation based on this section is on which the court always looks upon with disfavor, and it's unfortunate that the public authority like the Port Trust should, in all morality and justice, take such a plea to defeat a just claim of the citizen. Then it's a high time that government and public authorities adopt the practice of not relying upon technicalities for the purpose of defeating the legitimate claims. That's exactly what I'm submitting, Your Lordship. After all, this old man will get his money. And he's lying with them for so many years now.
Yes.
Amendment was in
No.
2015 man.
Oh, এমন জেরক্স করেছে দেওয়া যাবে না কোথায় গেল টাকা
Dismiss for default. We start from 2011 to 2026, my lord. My lord, I have relied, my lord, one judgment of division bench, my lord. Kindly see paragraph 15.
Which judgment?
Gautam Pal versus Union of India, my lord. Dated
Yes.
12 February 2026, my lord.
Yes.
Paragraph 15, my lord. In the facts of the present case, as noted above, the award was made and published on October 12, 2009. The respondent herein filed an application under Section 34 of the Arbitration Conciliation Act on February 10, 2010. Such application was disposed of on July 18, 2022. Appellant filed the execution proceeding resulting in the impugned order on February 7, 2025. The execution petition was filed after 12 years from the date of the award dated 12th October 2009. We are unable to accept the contention of the appellant with regard to the automatic stay as advanced before us. First, by the ground on which we cannot accept such contention is obviously binding precedent of Hindustan Construction Supra. Other ground is that the conduct of the appellant itself, Hindustan Construction was rendered in 2020. There is no reason why the appellant choose to file execution application only on February 7, 2025. In view of the authoritative pronouncement in Hindustan Construction, we do not find any ground. So, my lord, it is a clear case that they have filed after 15 years. And my lord, 136 apply here, Limitation Act. My lord, Article 136, my lord.
Yes.
For execution of any decree other than a decree granting a mandatory injunction or order of any civil court, 12 years. My lord, there is no civil proceeding pending, so they cannot take the advantage of section 14 also.
Take down.
Well, only
Anything
one
else?
thing. So, sorry, my lord, no, sorry, my lord. My land fund relied upon the Article 136 of the Limitation Act, 1963. But here I will only submit, not the judgment that my land fund relied upon. There was no execution application pending earlier, filed earlier. Here is a case where we have filed it, but there was an embargo put on us that you cannot execute because they have got it restored in the meantime. So, my lord, that was different. Now we are trying to file an application in that revival of that execution application. If it can be revived, then of course 136 will not apply. That's what the Supreme Court has said. So,
It's an application filed by the award holder seeking revival of EC 142 of 2010. Be revived and the instant EC form number 359 of 2026 be treated as continuing the execution application. It is stated by the learned counsel for the petition that EC 142 of 2009 was disposed of by order dated 19/7/2010. Full stop. Learned counsel for the award holder submits that the award holder had had preferred the present execution petition, seeking implementation of the award dated 18/7/2007. Full stop. The award letter had earlier challenged the said award by filing AP number 259 of 2001, which was dismissed for non-prosecution on 1/4/2010, right?
Yes, my lord. First dismissal on 1st April 2010.
1/4/2010, full stop. The award holder thereafter filed EC 142 of 2010 seeking execution of the award, full stop. AP 259 of 2009 was subsequently restored while order dated 19/7/2010, pursuant to which EC number 142 of 2010 was also disposed of, full stop. In the meantime, the award debtor initiated steps for settlement of the pending disputes with contractors and similarly situated persons, full stop. The award holder also applied for such settlement, however, the application was rejected by the letter dated 31/2025. Full stop. 31 on the ground that AP number 259 of 2001 was still pending. Full stop. It is submitted that AP 259 of 2001 had in fact already been dismissed by order dated 10/5/2011. In view of the above and the order dated 20th July 2010 in EC 142 of 2010, the award holder seeks revival of EC 142 of 2010. Full stop. Having heard the counsel for the parties and perused the material on record, this court is of the considered view that the award holder has filed the present execution petition for implementation of the award dated 18/7/2007. The award was challenged in AP number 259 of 2001 in under section 34 of the Arbitration Conciliation Act, full stop. The same was dismissed by this court while order dated 10/5/2011, full stop. Learned counsel, the award holder has not challenged the said order since then and has moved the present execution petition in 2026 by filing EC 359 of 2026 on 30th of July 2026. Full stop. There is no occasion to revive the earlier petition by way of this execution petition, since the same is barred by limitation. The present application is dismissed.
Good.
Along with that connector.
I'm good. Three.
My lord, I'm praying for not today, my lord.
Why?
My lord, this is a application, my lord, that has been filed, my lord, for transferring the consent term award dated 11th April 2025. My lord, it fell from the last occasion that there is already an existing execution pending in Bangalore. My lord, I have received. My lord was of the opinion, my lord, that it cannot, if there is an already existing execution case, this cannot be transferred to the Bangalore. My lord, then I have received instruction. They are in process in withdrawing the execution application pending in Bangalore so that it can be transferred, my lord.
But if you have already filed it, it's already there.
My lord, there in the judgment letter has already filed a section 47 saying that that Bangalore court has no jurisdiction because the consent term that was passed under section 12A of the commercial code, which has become an award now, that has to be transferred from Calcutta to Bangalore. So, my lord, eventually, my lord, the Bangalore case will get dismissed because the court is of the opinion, and also the after when the award holder taking steps for withdrawing the same so that it can be this particular execution can be transferred in the Bangalore court and steps can be taken there.
But if you have already filed a fresh one, you can withdraw this. That is already pending. Why should
kindly, my lord, in that case, again, the client has to kindly keep it pending, my lord, and let it appear in the next week. In the meantime, my lord, I will receive an instruction, my lord, I'll produce that order of withdrawal by way of a supplementary, and then my lord can take it up, my lord. My lord, kindly understand, my lord, and 2025 award, my lord, pass under section 12A for settlement paid 25 money paid through 25 checks. All checks were dishonored, my lord. Now execution. I don't know. I mean the award holder are doing everything, my lord, but the money cannot be recovered and also the award debtor is
filed the execution petition, madam.
sir,
That is the reason why you filed the
yes, my lord. But the fact is the Bangalore court is of the opinion that it should have been transferred from the Calcutta because the consent term was passed from the mediation committee of the High Court at Calcutta, my lord. And also they have filed a section 47. My lord, now this will go into further complication and appeal. And my lord, on the next week, my lord, kindly keep it on the next week. Much.
not today.
Court.
Sir, item number 4, I appear for the award holder, my lord. My lord, on the last occasion, my lord, by an order dated 16 July, my lord had directed the department to give a report on the service, my lord.
Produce the report. Produce the report of the department dated 5th August 2026. Despite service, none appears on behalf of the respondent. The respondents are once again granted an opportunity to file their affidavit of assets within a period of 3 weeks. The award debtors are granted 3 weeks time to file their affidavit of asset. Affidavit of service shall be filed on the next day.
My lord, only leave I'll serve on all addresses, my lord, all available addresses, my lord. That leave may be granted, so we'll.
Already been served on them.
My lord.
Serve on the same address.
My lord.
Five, your lordship, I'm for the petition.
But I'm for the award.
Lordship, I'm for the your lordship award holder. So there's a BSNL matter, your lordship, where they have deposited 75% to maintain the appeal, but they have not, your lordship, deposited the 100% to get a stay order. Now, your lordship, time to time the matter was adjourned, and thereafter, your lordship, I filed my execution application. Today, your lordship, the amount is already deposited with your lordship, the registrar original side. Many a times your lordship has given them opportunity so that the money can be deposited entirely with the honorable the registrar original side, but they chose not to do it. So there is no stay order, your lordship, on the arbitral award. Lordship has given an ample opportunity, and lordship kindly, I say MSME, your lordship, will not survive. Lordship kindly take page 72. This is a fund certificate. On the first occasion, they have deposited 25,37,376.75, and page 73 another 46,93,434 has been deposited. So today, your lordship, kindly take, your lordship, the tabular statement. I am praying, your lordship, that this amount, your lordship, which is already deposited with the registrar original side, may be disbursed in my favor. Prayer be.
Yes.
I appreciate lordship. We got enough opportunity which was given to us by your lordships to deposit 100% since it is the proceedings is arising out of MSME Act. But in compliance of the section 19, to maintain the petition under section 34, we have deposited 75%. But I am told today also receive instructions over telephone from my client BSNL authorities that they are going to deposit rest 25%, hardly 24 lakhs. Kindly give us 2 weeks time because we also filed section application under section 36(2). Where we are short for the stay of the operation of this execution process.
So as deposit the money in your 36(2). Who's stopping you from depositing the money?
We shall deposit.
Why you're not depositing? There's no stay.
As your lordship knows, this is a public sector undertaking.
So they get a different.
Only thing for getting approval, 75% we have deposited. Only rest 25%.
Set the order. How many years do you need for approvals?
My lord,
How many years?
my lord was pleased to grant us 3-4 opportunities.
Then
I appreciate lordship, but only one or last chance. As a last chance, kindly give us 2 weeks or 3 weeks time. In the meantime, we shall deposit. And my lord, as you
stop
lordship,
having this idea about government organizations.
lordship, my lord,
You don't stand on a better footing.
no, absolutely not. All litigants are on the same. That I also would appreciate.
Rather, you should comply by the orders passed by this court.
Lordship. Always, my lord. It is our obligations to comply, lordship. But we received the instructions from my client to they are ready and willing to deposit.
The award holder has preferred the present execution petition seeking implementation of the award dated 7/2/2023. Learned counsel for the respondent, award debtor, appears and states that he will file his affidavit of asset within a period of 3 weeks. List after 4 weeks.
As a last chance, your lordship, and then you press.
Six.
Item number 6, my lord, I expect to appear before your lordships in virtual mode. My lord, this is an execution application coming up for the first time. On last occasion, my lord has specifically asked me one question that is it an unilateral appointment or not? My lord, it is an unilateral appointment, but the award was passed on 28th July 2015. But I'm carrying a judgment of the Honorable Supreme Court, my lord, the Bhadra International, which specifically says that the section 12.5 will be applicable from the promulgation of the Amendment Act 2015. That is, my lord, 23rd October. But the award was passed prior to that, my lord, 28th July 2015, my lord. I'm only humbly praying before your lord for issuance of notice under Order 21/22, my lord.
The award holder has preferred the present execution petition seeking implementation of the award dated 28/7/2015. Full stop. The execution petition is filed beyond the statutory period of 2 years. Full stop. The department is directed to effect the service upon the award debtors in terms of Order 21, Rule 22 of the Civil Procedure Code 1908. The department shall file a report on the next returnable date. Give after 4 weeks, 6 weeks.
Grateful, lordship.
Seven.
I appear for the award holder.
Yes.
There's a section 47 application. The challenge to the execution is the ground of nullity. Your lordship has already on the last occasion seen the cases the Electro Steel and MMTC. Both these judgments ultimately say that the scope is limited and it's only in nullity. Your lordship's judgment in the LNT matter, I just want to show one line. I will not repeat what has been stated in Electro Steel and MMTC. Well, if your lordship's judgment in did you say LNT?
Yes.
I just want to show one paragraph in your lordship's judgment in the LNT matter. I don't know whether a copy was handed
I
up.
have.
Well, please see paragraph 29. Well, your lordship has said, Section 36 of the Act provides that an arbitral award shall be enforced under the Code of Civil Procedure in the same manner as if it were a decree of court. By virtue of this statutory fiction, questions arising in the course of execution are governed by Section 47 of the CPC, which provides that all questions relating to execution, discharge, or satisfaction of the decree shall be determined by the executing court. The power of the executing court is therefore expressly anchored in Section 47 of the CPC, read with Section 36. The scope of this power is authoritatively settled by the Honorable Supreme Court is 3-dimensional. The executing court cannot go behind the decree, cannot question its correctness, but is expressly empowered, and well, this is what I rely on, and indeed obligated to ascertain whether the tribunal that passed the award possessed inherent jurisdiction to do so. Now, well, when we talk about inherent jurisdiction, well, we talk about the power to receive a plaint. For example, if we are talking about filing a suit in respect of a land which is outside the jurisdiction, then that would be barred being a suit for land. So the court would not have the power to receive it. Now, the objection can be taken at the stage of receiving the plaint, or if the court scrutinizes at that moment, for example, where leave under clause 12 of the latest patent is sought. Or the objection can be taken in the form of an application under Order 7 Rule 11 saying that the court does not have jurisdiction to receive the plaint because the suit is a suit for land. Or for example, where a suit is filed in respect of oppression mismanagement, which is now covered by the provisions of the Companies Act, which says it has to go to the NCLT. Or suit concerning insolvency, which has to again go to the insolvency courts because of the provisions. So the power to receive, the objection can be raised at the threshold, when the court is scrutinizing the matter, for example, granting of leave, or it can be taken by the parties once the court receives the matter. Now, so far as this is concerned, here, what had happened is, there was a consortium, which was awarded a contract by Hindustan Copper Limited. Now, the consortium, has been accepted to be, a partnership or in the nature of a partnership, and, partnership principles have been made applicable to it. Well, so far as this consortium is concerned, there were 4 members of the consortium. Well, the lead member of the consortium, a company by the name of IVRCL, went into liquidation. Well, after it went into liquidation, it applied for extension of the time to perform the contract. Now, just to give your lordship 2 dates, your lordship need not record it. Well, the contract was originally expected to be performed in 60 months. That's 5 years. Well, at that time expired in 2020, April 2020. Well, IVRCL was admitted into insolvency and thereafter went into liquidation in 2018, February 2018. Well, thereafter, it paid for extension of time, and extension of time was granted because even the company in liquidation can continue to carry on business for beneficial winding up. It was granted extension of time for 20 months and 20 days because that is what it was contractually entitled to. That period ended in December 2021. Thereafter, it sought extension till May 2026. So, initial contract would have expired in April 2020. Initial contract period is 5 years. They asked for an extension of a further 6 years. Well, that is where Hindustan Copper came forward to say that no, we have given you whatever extension you're entitled to, 20 months and 20 days. Beyond that, you're not entitled to extension. So, the contract was terminated on the expiration of that period. Now, after that, the requirement of the law is when it's a consortium, then, the consortium will have to authorize all members of the consortium because it's the nature of a partnership. Will have to authorize, the consortium or, a single entity which is a partner of the consortium to, file arbitration proceedings. But that did not happen. This objection was taken. Before that, may I just show your lordship one document? That is, the joint bidding agreement. This your lordship will find at volume 2 of the section 47 application. Kindly have a look at page, this is annexure A. This should be page, 20. Page?
Page 20.
This is, I'm sorry, volume 1. Volume 1? No, volume 1, page 20. Volume 1, page 20. My mistake, I'm sorry.
Volume 1, page?
20, my lord.
Yes.
Well, this is the agreement that was entered into between the consortium members. Well, this is a 2011 document. Well, the first party is IVRCL Limited. Then, the second party is a company by the name of MCCDL. Well, this is a Ukrainian company. The third party is Technomin Construction. Well, this is an Indian company. And then the fourth company is Davy Markham. Well, this is a British company. And here your lordship will see that Hindustan Copper Limited, by its requests for qualification, etc., shortlisting bidders for the development of underground mine of 5 million tons per annum capacity in Malanchkand copper project. And then B, application of the consortium, which is ultimately recognized as IVRCL, MCCDL, TCL, DM, was considered to be qualified in accordance with RFQ. And then if your lordship sees clause number 2, the parties do hereby irrevocably constitute a consortium for the purpose of jointly participating in the bidding process for the project and submitting the bid for the project. The parties hereby undertake to participate in the bidding process and submit the bid only through the consortium and not individually or through any other consortium constituted for this project. The rest of it is not material. Just wanted to show you lordship that a consortium came to be constituted. And ultimately, it is the consortium that was awarded the contract. Now, so far as this is concerned, now, if your lordship sees, I'll just straight away take your lordship through the law. So far as the consortiums are concerned, they are really in the nature of partnerships. The first judgment I'd like to show your lordship in this regard is the case of New Horizons.
What is your point, Mr.
My point is this. Section 19(2) of the Partnership Act applies to consortiums. That has been consistently held by courts. Now, Section 19(2) says that you cannot, with the implied authority of the other partners, file an action. May I straight away just request your lordship just to see that provision instead of narrating what it says. I want to take your lordship to the Partnership Act, just one provision. Section 19(2). Should I copy it? Okay.
Partnership Act, give me a copy.
May I just hand up a soft copy to your lordship? Nowadays, everything comes in the tab. It's a very bad habit that we've developed.
It's not quoted in the judgment.
No, I'll just hand it up to your lordship. Kindly allow me.
Quote the
Just a very short section.
yes. Subject to provision.
Implied authority of a partner as agent of the firm, subject to the provision of Section 22 of the Act of 22, the act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. The authority of a partner to bind the firm conferred by this section is called his implied authority. Then subsection 2 is important. In the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to submit a dispute relating to the business of the firm to arbitration. So, there has to be express authority. The implied authority of a partner does not extend to submitting disputes relating to the business of the firm to arbitration. That is what we are relying on. Now, in this case, IVRCL goes into liquidation. We come to know later that MCCDL, which is the Ukrainian company, well, that had, my lord, removed itself from, my lord, the participation in the project, because once, my lord, the notice or news of IBRCL's liquidation came to the forefront, MCCDL approached Hindustan Copper Limited individually, saying, give me the work. And, my lord, so far as Devi Markham, the other member of the consortium, is concerned, it had gone into liquidation even before, my lord, the arbitration commenced. Gone into liquidation. That fact we did not know. We came to know, my lord, much later, after, my lord, the arbitration was over. Now, my lord, without the authority, express authority of, my lord, the other consortium members, there could not have been a reference made by, my lord, IVRCL to arbitration, my lord, on behalf of the consortium. My lord, that reference, my lord, was therefore, my lord, something, my lord, that did not have the requisite authority of the consortium. Now, my lord, I'll not trouble your lordship with, my lord, the judgments that I had handed up to your lordship. My lord, kindly take it from me. My lord, this is, my lord, noticed in several other judgments. My lord, New Horizon and then Gammon India, Supreme Court has expressly stated that, my lord, so far as a partnership, a consortium is concerned, a joint venture is concerned, it is in the nature of a partnership. And, my lord, have applied the provisions of the Partnership Act to this. My lord, what I'd like to show your lordship is, my lord, this being the position of law, well, may I just show your lordship just one paragraph of, my lord, New Horizons, since your lordship has the judgment, just one paragraph. My lord, paragraph 24. Well, I'll not, well, there's a lot of discussion on the subject. The expression joint venture is more frequently used in the United States. It connotes a legal entity in the nature of a partnership engaged in the joint undertaking of a particular transaction for mutual profit, or an association of persons or companies jointly undertaking some commercial enterprise wherein all contribute assets and risk. Well, thereafter, this was followed in Fakir Chand Gulati by the Supreme Court. And then, well, just for record, I'll hand up to your lordship the case of Gammon India, where, well, there's a more, well, express discussion on this aspect of the matter. Here, lordship will find, well, a very detailed discussion from paragraphs 23 to 30. Well, I'll not, well, read it out. Then, my lord, now, my lord, may I show your lordship, my lord, one document which unfortunately, my lord, is referred to, my lord, partial in my application, but not there. Well, this is, my lord, a part of, my lord, the records. My lord friend is aware of it. Well, just may I hand up a copy of, my lord, an order of the tribunal. Somehow, my lord, it has not been annexed to either the, my lord, Section 47 application or to, my lord, the execution petition. Well, this is the tribunal's order. Well, that was passed in the Section 16 application that had moved. I'll take your lordship through it, my lord, in details later. But please just see, my lord, paragraph 6 once. An order of, my lord, 24th July 2022. As regards the first point, in the opinion of this tribunal, as 4 different companies formed the consortium for the purpose of bidding in the process of a tender, and the consortium was selected, it should be presumed that they formed a partnership for the purpose of doing this particular job. So, my lord, the court, the tribunal also recognizes, my lord, it's in the nature of a partnership. My lord, kindly, my lord, keep this order aside for the time being. I shall take your lordship through this, my lord, a little later. Now, my lord, may I take your lordship through what was filed? Now, my lord, please see the statement of claim, my lord, that your lordship will find, my lord, at page 64 of the application. So, my lord, the first point is there is acceptance of the fact that, my lord, this is really a partnership in all its facets and character.
Page
64. Well, kindly see the parties. Well, IVRCL, MCCDL, TCL, DM consortium. A consortium of 4 companies. Well, this is the claimant. And then, if your lordship sees page 65, para 1.1. the claimant consortium was awarded the contract for development of the underground mine. And then I'll show you Lordship straight away to my lord how this was verified or affirmed. That's at page 172. That should be in volume 2, my lord. 172.
Yeah.
I, Ramchandra Shrimali, son of late Jamnalal Shrimali, aged about such and such, by occupation working for gain at IVRCL, MCCDL, TCL, DM consortium of such and such. It says, I am the authorized representative of IVRCL, MCCDL, TCL, DM consortium. As such authorized representative, I am authorized to affirm this affidavit on behalf of the IVRCL, MCCDL, TCL, DM consortium. Well, let me just pause here for a moment. So he says he has been authorized by the consortium. Now, my lord, today if the consortium authorizes a person, then my lord, I have no quarrel with it. But then he has to show that my lord, the consortium has in fact authorized him. My lord, our contention was, my lord, as soon as the statement of claim came to be filed, my lord, along with this affidavit, my lord, we filed an application under section 16(2) of my lord, the Arbitration Act before the tribunal, saying that my lord, there is no authority to receive this. They have no my lord, right to file this application, or they maintain the reference, and my lord, hence it should be my lord, dismissed. Well, I could have done two things. I could have my lord, challenged it under 16(2), or my lord, as they say, my lord, the parallel to my lord, section 711 application would be, my lord, I could have filed an application under section 31 subsection 6 for an interim award saying that please dismiss it. My lord, I chose to file an application under section 16 saying that the tribunal does not have jurisdiction to receive this, my lord, reference. Now, my lord, so far as that application is concerned, that application is, my lord, at page 173, the very next page. It starts there. Well, I had taken the point of, my lord, IVRCL having gone into liquidation also, but my lord, that is not really, my lord, material. Please see paragraph 6. It will appear from the statement of claim, paragraph 6, my lord, at page 176. It will appear from the statement of claim, copy whereof is annexed, etc., that the same has been affirmed by one R.C. Shrimali as the authorized signatory of IVRCL consortium. We are saying that as the event of liquidation of IVRCL in itself resulted in the disruption of the consortium, there could be no question of IVRCL representing itself to be a part of the consortium or of its filing the statement of claim either on behalf or as a part of the consortium. The statement of claim has, however, been sought to be filed on behalf of the consortium even after it became disrupted by liquidation. So, my lord, this point was taken. Now, my lord, this ultimately was opposed. The section 16 application was opposed by filing an affidavit, which, my lord, your lordships will find, my lord, immediately thereafter at page 181. Now, our point is very clear and specific, that you don't have the authority of the consortium to file it. And, my lord, here, there is no implied authority. Section 92 requires that there has to be express authority. Now, my lord, please see page 182, paragraph, my lord, 3A. This is the response. It appears that the respondent is alleging that R.C. Shrimali, I am incompetent to affirm the statement of claim on behalf of the claimant consortium, and as such is alleging that the Honorable Tribunal is not competent to commence the reference or proceed with it on the statement of claim, and that the reference ought to be terminated. So, my lord, he is accepting the fact that he has filed it on behalf of the consortium, but he is saying that he has the authority. Now, my lord, so far as that is concerned, please see paragraph C, page 183. IVRCL Limited is only one member of the consortium, and the fact that presently liquidation proceedings is going on pending against the said member of the consortium does not disentitle the consortium to file the statement of claim. I accept this. In any event, the interest of IVRCL is to be looked at after the appointed, looked after by the appointed liquidator, and the liquidator has authorized Shrimali to act in this behalf. Now, my lord, this document a resolution is, my lord, referred to, that, my lord, will find at, my lord, page 191. Now, my lord, this is, my lord, an authorization by the liquidator. Now, my lord, liquidator is liquidator not of the consortium. Liquidator is liquidator only of IVRCL. Now, my lord, what does he say? Resolved, the liquidator recommended the note submitted after some discussion. It was resolved that the company, now, my lord, the company is only IVRCL, do hereby authorize Ramchandra Shimali, son of such and such, project head, to sign and submit the final bill and all communication letters, etc. And then the last line before 1, 2, 3. And to do all or any of the following acts on behalf of IVRCL, MCCDL, TCL, DM Consortium. Now, the liquidator of IVRCL could not have authorized Mr. Shimali to act on behalf of the consortium. That has to be done by the consortium or the independent members of the consortium. He purports to, my lord, pass a resolution, being the liquidator of only IVRCL Limited. He purports to pass a resolution and to authorize by that resolution, my lord, Shimali to do all acts for and behalf of the consortium. And this includes, please see Roman item number 2, serial number 2. This attorney is authorized to refer the disputes to arbitration, file any cases on behalf of the consortium in any court in respect of matters relating to the work. Now, my lord, this authority, my lord, so far as the liquidator is concerned, the liquidator could have authorized Shimali to do an act on behalf of the company in liquidation, that is IVRCL. The liquidator did not have, my lord, the requisite authority to, my lord, authorize Shimali to act on behalf of the consortium. Now, my lord, so far as this is concerned, well, ultimately, my lord, I shall show your lordship also the provisions of the Insolvency Act. But, my lord, this is the first, my lord, resolution that is relied on. Now, my lord, coming back to the affidavit in opposition, please see, my lord, what he says later. First, he relies on this document. Then, my lord, please see page 183 again. First, he refers to the resolution of 3rd March 2022. Then, paragraph E at page 183.
Which page?
Page 183, paragraph E.
E of what?
My lord, E of the, my lord, volume 2 of the petition. My lord, this is a part of the affidavit in opposition filed to the section 16 application. My lord, when I take the point of objection, my lord, this is what Shimali says. He says first, my lord, at paragraph D at page 183,
yes,
that, my lord, there is this resolution of 3rd March 2022 to which I have taken your lordship. Then he says, the respondent is well aware that by a power of attorney dated 28th July 2011, the members of the consortium designated, nominated, constituted, appointed and authorized one Srinivasa Rao, Chief Operating Officer, as special projects as its attorney. Copy of the said power of attorney is annexed, but that copy of power of attorney is not there. It was referred to but never annexed. Now, at that point of time, there could not have been any authority to initiate arbitration. This is in 2011. Then paragraph F. By a board resolution of IVRCL Limited, not of the consortium, passed on 29th May 2015, the company authorized Mr. Srinivasa Rao to subdelegate all powers of power of attorney for the lead member dated 28 July 2011. Now, my lord, I'll take your lordship through this document which is annexed. So, my lord, the power of attorney of 28 July 2011, which is supposed to be a power given by the consortium, is not annexed. Then, my lord, the next reference is to a board resolution of IVRCL Limited, passed on 29th May 2015, which authorizes Mr. Srinivasa Rao to subdelegate all his powers. And it says that, my lord, pursuant to this, my lord, authority, my lord, Srinivasa Rao subdelegated his powers to, my lord, one Mr. my lord, C.S. Gopal. These documents are on record. I shall take a lordship to that. And then please see page 184. G. C.H.S. Gopal thereafter issued a further power of attorney dated 3rd June 2019 in favor of Chetan Kumar Jain to do all acts of or on behalf of the consortium. Power of attorney was thereafter cancelled on 7th January 2021. Said CHS Gopal subdelegated all powers mentioned in the power of attorney given to Chetan Kumar in favor of one Ramchandra Shimali to do all acts. And then, my lord, please see a few lines thereafter. Thus, the respondent, that is HCL, was at all material times since January 2021 aware that the consortium was being represented by Ramchandra Shimali. Now, let may I just show your lordship these documents? I don't need to trouble your lordship with the rest of the text of the opposition. Well, I have already shown your lordship the resolution of 3rd March 2022. That was at page 191. Now, please see, now, the resolution of 29th May 2015. Well, that is at page 12. Or I'm sorry, page 192. Well, the running page 12 of the affidavit in opposition. Now, the power of attorney given by the consortium on 28th July 2011 is not there. At page 192, your lordship will find excerpts from the minutes of the meeting of the executive committee of the board of directors of IVRCL Limited, not of the consortium. What does it say? Well, it says issuance of authorization to Mr. Srinivasa Rao, executive director, to subdelegate all powers to Mr. C.S. Gopal, executive director IVRCL, pursuant to the power of attorney for the lead member of consortium dated 28 July 2011, executed by consortium members such and such, and Devi Makham in favor of Srinivasa Rao, now redesignated such and such, in relation to development of underground mine, 5 million ton per capacity, etc., then resolve that. The company do hereby authorize Mr. Srinivasa Rao to subdelegate all powers of the power of attorney for the lead member of 28 July 2011 in favor of C.S. Gopal. But, my lord, what was the power given to Srinivasa Rao, my lord? We don't know. Well, obviously, in 2011, there was no arbitration in contemplation. So, my lord, that power, my lord, was not there. And, my lord, we have asserted
Shall
this.
we get into all this at the stage of 47?
Well, it's like this. Well, at 47, my lord, is ultimately a question touching the jurisdiction. Well, there is no inquiry. If your lordship had to get into a factual inquiry, well, I would appreciate that, my lord, your lordship need not go into it. But, my lord, when your lordship is not required to go into a factual inquiry, all these are admitted facts. And, my lord, I'll show your lordship from the award that there's no factual, my lord, discontent, my lord, so far as, my lord, what we have stated is concerned. My lord, then, my lord, it's a matter that your lordship, my lord, will respectfully go into for the purpose of deciding. My lord, and, my lord, there is a very significant, my lord, sum awarded against Hindustan Copper Limited, my lord, which ultimately, my lord, is fastened to, my lord, this absence of authority. Absence of authority is absence of authority to receive the reference. Well, I shall show you, lordship, but there are judgments, my lord, of various courts which have been, my lord, completely overlooked by the tribunal. And the tribunal, my lord, with the greatest respect, you'll find, well, it is a really argumentative award, in the sense that, my lord, when we asserted, my lord, on the basis of section 19 and, my lord, on the basis of judgments of the court, that, my lord, there was no authority. Well, the tribunal goes on to say that, well, they had made a demand for arbitration, and you responded to the demand for arbitration by nominating your own arbitrator. So, therefore, you are stopped now from raising this contempt. Tribunal says that so far as this is concerned, they have not sued as a consortium. They have not sued on behalf of the members of the consortium. They have sued as the consortium itself. And the tribunal goes on to say that, look, under section order 30 of the Civil Procedure Code, any two members could have filed.
The great petition for 34.
Well, 34 is in Jabalpur courts. That is why, my lord, we are troubling.
Just want to burden me with this.
Well, 34 is, my lord, very
interrupt
expansive.
once, my lord.
34 is, my lord, on many points. There are various aspects, my lord, for which we have sought setting aside of the award. But, my lord, we are limiting ourselves to only, my lord, this 47 aspect, only on this issue.
But everything that my learned friend has argued today has been argued. It's reflected in the award.
I should show you,
Cannot go beyond the award.
No, I shall show you, lordship.
And
today,
the merits of that cannot be gone into a 47.
Finish, otherwise you'll never
Yes.
go to Jabalpur. You stay here.
My
Go there or not? Let him finish. Otherwise,
Yes,
you'll
yes.
be stuck here.
Yeah,
You won't travel to Jabalpur. Yeah.
I am conscious. I will be showing the award. Of course, I cannot, my lord, escape that. Now, my lord, all the time trying to show your lordship is, my lord, here. My lord, when a challenge was made to the authority of Mr. My lord Shrimali to, my lord, file the reference, my lord, he says, I have been authorized by, my lord, first the liquidator. Liquidator is not the liquidator of the consortium. Then
I'm absolutely sure, Mr. Saha, that you have argued all this in your award.
yes, my lord, we have.
And once that has been passed, to apply 47 and throw you out or throw the award out at this stage, not possible in 47.
My lord, here, my lord, may I just show your lordship, my lord? I'll tell your lordship this. That, my lord, if your lordship finds, my lord, of course, my lord,
We
whenever
are
my lord,
going against the basic principle, against the legislature, against the Arbitration Act, everything. If we start interfering in 47 like this,
my lord,
no way.
my lord,
Then
your
I think
lordship,
we are putting the entire Arbitration Act under a
no, my lord,
cap.
I completely appreciate, but my lord, since your lordships have now, my lord, said that, my lord, notwithstanding my right to approach a 34 court, I have a right, my lord, a very limited right to, my lord, approach your lordship, my lord, on the aspect of, my lord, a jurisdictional error, my lord, which would ultimately resound in, my lord, a nullity. My lord, then, my lord, I may trouble your lordship. My lord, I can only show your lordship this. I will not, my lord, not travel beyond the 19.2 point at all. Of course, the arbitral tribunal has gone into this question. Of course, this was argued. But if your lordship sees that the arbitral tribunal has, my lord, completely, my lord, acted in error, and, my lord, for this reason, same 19.2 question. Well, on the question of maintainability, other courts have, my lord, held that, my lord, the reference was not maintainable.
What will happen to your 34 if I give findings?
Well,
in 47
yes.
regarding some of the issues which you're arguing.
No, my lord. If today, my lord, this is a threshold question, my lord, because we are
On the threshold question,
on nullity.
I give my, because whatever you're arguing, I'll decide it.
If your lordship holds it's a nullity, my lord, then the whole award goes.
If I hold it's not a nullity,
then, my lord, I have to go back to the 34 court.
That's what I'm saying.
Yes.
With my observation.
My lord, but that's
my observation.
My lord, then, my lord, this, my lord, will be res judicata. Then, my lord, this question, if your lordship decides this question on merits, then this will be res judicata. I cannot go back and re-argue this, my lord, the same point before, my lord, the Jabalpur court.
That's
Yes.
exactly what I'm saying.
Yes, my lord. But that, my lord, is something that
something which you have to think about.
Yes, yes, my lord, I'm, my lord, conscious of that. Well, if your lordship, my lord, says that, my lord, this is not a 47 question, then, my lord, that keeps the point open for my argument before Jabalpur. If your lordship, my lord, holds that, my lord, yes, you have raised the 47 question, but I hold it against you, then, my lord, that will be, my lord, res judicata or issue estoppel so far as the further Jabalpur court is concerned. Well, that, my lord, is something that I am conscious of. And I'll show you. Just one. Now, my lord, I just want to show you, lordship, just 3 or 4 documents, my lord, we have done with the documents. This is not something, my lord, that I'm asking your lordship to go into the facts of the case. Just on the authority, what he, my lord, ultimately says by way of authority. So, page 192, my lord, he says that, my lord, the company authorizes Srinivas Rao, is authority given by company. It says this authority flows from, my lord, an authority of the consortium dated 28 July 2011, which, my lord, is not on record.
That's there. Well, since he said it for the 4th time, supplementary first annexure, it's there.
Okay.
Supplementary.
Supplementary.
Confirmed on 19th February 2026.
We took leave and all the documents that are referred to in the award are there, like as far as the authority are concerned.
Well, I'll just, my lord, supplementary to document.
And it was there in the, before the
section 16 application.
Well, I'll show that document.
Page 12 of the Calcutta statute.
Not given me the supplementary. I don't even know there's a supplementary. What, do you think
So yours is. I'll give mine. I'll give mine. Mine is not much.
I can't read my handwriting.
Look, there's a supplementary affidavit. Unfortunately, I don't have it, but I know what is there in this document.
Well, your lordship will find the supplementary affidavit page. It seems like this is page 12 of the supplementary affidavit.
Sorry.
He has been nominated.
No, no, let me show you, lordship. Well, power of attorney, whereas HCL has invited bids, then my lord, next is whereas IVRCL Limited, my lord, this is the consortium, being members of the consortium are interested in bidding. Now, my lord, please see the last line of the my lord, page 12. Whereas it is necessary for the members of the consortium to designate one of them as lead member with all powers necessary and authority to do for and on behalf of the consortium all acts, deeds, and things as being necessary in connection with the consortium's bid for the project and its execution. So, my lord, confined to bid and execution of the bid. My lord, not my lord, to arbitration. There is no implied authority to refer disputes to arbitration. And my lord, then if your lordship sees, my lord, it says, my lord, after my lord, the Srinivasa Rao is mentioned here, hereby irrevocably authorize the attorney with power to subdelegate and conduct all business for and on behalf of the consortium or any one of us during the bidding process, and in the event of the consortium is awarded the contract during the execution of the project, and in this regard, to do on our behalf and on behalf of the consortium all or any of such acts, deeds, or things as are necessary or required or incidental to the submission of its bid for the project, including but not limited to signing and submission of all applications, bids and other documents and writings, participation in bidders and other conferences, respond to queries, submit information, documents, sign, execute contracts, undertakings consequent to acceptance of the bid, etc., in all matters in connection with releasing out of the consortium's bid. Nothing, my lord, to do with, my lord, reference to arbitration or litigation. Well, that is why we say it is confined. It does not extend beyond that. So, my lord, if today it is this power that is being subdelegated, then, my lord, this power is not, my lord, a power which extends to the power to refer disputes to arbitration.
Yes.
Now, my lord, page 12 at page 192, my lord, ultimately is, my lord, subdelegation of a power, my lord, given to the lead member of the consortium by the consortium on 28 July 2011. 28 July 2011 talks about to do all things in connection with the bid and in connection with the execution of the project. And then, my lord, the next document at page 193, well, it is the power of attorney that, my lord, Mr. Srinivasa Rao gives, well, to act in accordance with the resolution. Well, this is the power that's given to Mr. C.S. Gopal. And well, please see the language. I, Srinivasa Rao, Executive Director, such and such, in accordance with the resolution dated 29th May 2015, passed by the Executive Committee of the Board of Directors, do delegate all the powers pursuant to the power of attorney of the lead member of the consortium dated 28 July 2011, which does not extend to arbitration. And then, my lord, the next document, my lord, that you'll also find at page 195. Well, this is an authorization given by IVRCL Limited, the company, pursuant to the power of attorney dated such and such, executed in my favor for the development of underground mine, etc. I, C.S. Gopal, do hereby subdelegate all such similar powers mentioned the power of attorney dated 3rd June 2019 to Chetan Kumar Jain. And my lord, then finally, we have, my lord, the last document, that is, my lord, page 196. Chetan Kumar Jain's power is cancelled and my lord, Shrimali is authorized. That your lordship will find, my lord, the last document is important. Annexure F at page 198. I'll just read the first, my lord, few lines at page 198. This is a special power of attorney. Now, my lord, this date is very interesting. My lord, please see, my lord, this is a power of attorney dated 2022. This is after the disputes arose. So, my lord, before 2022, it is, my lord, something that is carrying on from 2011 onwards, there is no power to refer disputes to arbitration. 2022, by this power of attorney, ICS Gopal, such and such, pursuant to the power of attorney dated 7 January 2021 of IBRCL, MCCDL, TCL, DM Consortium, do hereby execute this special power of attorney in favor of Ramchandra Shimali, such and such, to sign and submit final bill. Then please see the last line, and to do the following acts. Then serial number 2 is, this attorney is authorized to refer disputes to arbitration. Now, my lord, today, if we look at, my lord, the 2011 document as a source, because that is the only document, my lord, which is the document executed by the consortium, then that does not, my lord, authorize, my lord, to do an act beyond, my lord, bidding and execution of the project. So, my lord, there could not have been any authority granted on this basis, my lord, to Gopal or to, my lord, by Gopal to Shrimali to, my lord, make a reference to arbitration. So, my lord, this is what, my lord, he has said. Now, my lord, so far as this is concerned, my lord, these are, my lord, the documents. Now, my lord, when we talk about, my lord, your lordship will now once kindly come back, my lord, to the order that I have handed up, the 24th July 2022 order of the tribunal. My lord, paragraph 5. This is, my lord, page 4 of the order. This tribunal proposes to take up the last point at the outset. It is now settled law that even if there is any illegality in verification of a pleading of the statement of claim, the same is not fatal unless, in spite of direction given by the court or tribunal, such defect is not removed. Therefore, merely because the statement of claim has been affirmed by a person having no authority, such fact in the opinion of the tribunal cannot be brought within the purview of 16(2), as this tribunal, even if it is found that the verification is not in accordance with law, can always permit the claimant to get the statement of claim verified by an appropriate person. My lord, may I pause here for a moment? My lord, they, my lord, were, my lord, made acquainted with the objection that, my lord, there is no authority of Shrimali to, my lord, file the statement of claim on behalf of the tribunal or behalf of the consortium. They had a, my lord, opportunity to, my lord, bring the authority of the consortium on record. That is what the tribunal noticed. My lord, they could not bring it on record. Then, my lord, I have shown your lordship, my lord, the recognition of, my lord, the fact that the joint venture is a partnership at paragraph 6. My lord, I'll just place the rest of the paragraph and, my lord, 2 paragraphs thereafter. As regards the first point, in the opinion of this tribunal, as 4 different companies formed the consortium for the purpose of bidding in the process of a tender, and the consortium was selected, it should be presumed that they formed a partnership for the purpose of doing this particular job or business. It is now settled law that when a particular partner in a partnership in liquidation, although the firm is dissolved unless otherwise provided in the contract, yet the other partners may, in the absence of a contract to the contrary, continue with the claim or claims in their individual capacity. Over and above, it appears from the averments made on behalf of the respondent itself in paragraph 4 of the application under section 16(2) of the Act, that even after knowledge of liquidation, respondent extended the time for completion of the project. Be that as it may, the effect of the above facts and the provisions of the terms of the contract between the parties and the consequences thereof on the ultimate fate of the maintainability of the claim are within the jurisdiction of this tribunal to decide. However, it appears that such stage has not yet come, and the tribunal will decide those points on merits accordingly only after filing of the statement of defense and evidence is led by the parties. Other point raised in the application under section 16(2) of the Act is also correlated, and as such, it requires adjudication on a full-fledged trial. Consequently, this tribunal holds that the disputes raised here by the respondent does not come within the purview of section 16, and it cannot by any stretch of imagination be contended that this tribunal lacks jurisdiction to go into those questions. So, well, this is how, well, the matter was dealt with. So, what the tribunal said essentially is that we'll go into the questions later. Now, well, so far as this is concerned, now, well, if your lordship will see, my lord, what we had argued, my lord, your lordship will find, my lord, from the records. But my lord, may I just show your lordship the law on the subject now? My lord, the first judgment that I'd like to show, because my lord, your lordship is now concerned with, my lord, what would be the scope of the court's interference. My lord, may I show your lordship a Supreme Court judgment, 1970, Volume 1, Supreme Court Cases, page 670. My lord, please see paragraph 7 and 8 of this judgment. My lord. ঠিক আছে, দেখুন। My lord, these are, my lord, this is what the court does, as your lordship has said, that, my lord, there's an obligation. And, my lord, what are the fetters or limits on that obligation? This also recognizes that. When a decree which is a nullity, for instance, where it is passed without bringing the legal representative on record of a person who was dead at the date of the decree, or against a ruling prince without a certificate, is sought to be executed, an objection in this behalf may be raised in a proceeding for execution. Again, when the decree is made by a court which has no inherent jurisdiction to make, objection as to its validity may be raised in an execution proceeding if the objection appears on the face of the record, where the objection as to jurisdiction of the court to pass the decree. Now, this is the inhibiting factor. Where the objection as to the jurisdiction of the court to pass the decree does not appear on the face of the record and requires examination of the questions raised and decided at the trial, or which could have been but have not been raised, the executing court will have no jurisdiction to entertain an objection as to validity of the decree, even on the ground of absence of jurisdiction. My lord, this is the law. So, my lord, if today it is something that, my lord, requires, my lord, adjudication at a trial, then your lordship will not go into it, even if it's a jurisdictional question. Now, my lord, here, my lord, there is no dispute. I shall show you, lordship, that, my lord, there was no, my lord, dispute with regard to, my lord, the authority. And that is what the tribunal has held. My lord, the tribunal has gone on, my lord, in a converse, my lord, logic, my lord, to find, my lord, something to empower Mr. Srimali. But, my lord, so far as 19.2 is concerned, there is no answer. Now, my lord, if your lordship will kindly, my lord, have a look at one or two judgments, my lord, before I take your lordship, my lord, to the award. And I have shown your lordship, my lord, section 19.2. Now, my lord, if your lordship will kindly have a look at, my lord, three judgments, my lord, of the Delhi and the Bombay High Courts. Well, the first judgment is, my lord, in the case of Geo Miller, well, that is reported in, well, I have the Manupatra citation, but well, it may not. We have handed up. No. Well, have I handed up to your lordship, my lord?
Which one? Only request.
Well, I'm sorry.
Which one?
Well, I'm sorry, my lord. There.
No,
Well, this is a judgment, my lord, of the Delhi High Court. Well, I just see whether the paragraphs, my lord, tally. My lord, I have the Manupatra, my lord, citation. Yes, my lord. Well, please see paragraph 6. The consortium / joint venture bid for the project. Then your lordship will skip over, my lord, the paragraphs in between and come to paragraph 17.4. The MOU also contained an arbitration clause. With no progress being made in the project, ATIPL issued letters calling upon the MD of Unitech Limited to distribute share of profits to the ATIPL.
Which paragraph?
Well, your lordship, 17.4. I hope, my lord.
Give us
I'll my lord, read from the SCC copy. My lord, kindly give me a moment. Yes, well, please see paragraph 15. Well, I'll read from this judgment. I'll not trouble you lordship with the corresponding. Please see paragraph 15. A preliminary objection was raised. That's how it starts.
Yes.
A preliminary objection was raised by Ms. Shilpa Singh, learned counsel for the respondent, regarding maintainability of the application. She pointed out that GeoMiller was not, in its individual capacity, a party to the arbitration agreement, which was essentially between the SPV and BIDCO. Then, my lord, will please see that, my lord, so far as this is concerned, paragraph 20. MOU also contained an arbitration clause. With no progress being made in the project, ATIPL issued letters calling upon the MD of Unitech Limited to distribute share of profits of the ATIPL. With the respondents failing to reply, ATIPL invoked the arbitration clause and sought the appointment of an arbitrator by filing arbitration petition. One of the objections to the ATIPL filing the said petition as raised by Unitech Limited was that the petition was not maintainable at the instance of ATIPL alone. The agreement was only with the party of the first part, which comprised ATIPL and other members of the RG group. The question that arose was whether ATIPL could alone bring forth an arbitration petition. Well, this was an issue. Then, well, the arbitration clause is reproduced. Thereafter, if your lordship will, my lords, kindly skip over and come to, my lord, paragraph 26. It was then contended that the agreement has been signed not only by Gammon India but also by GeoMiller, and therefore GeoMiller could in its own capacity seek to invoke the arbitration clause. The court is unable to agree with the above submission. The wording of the agreement is clear that the consortium would be represented through Gammon India Limited, lead member of the consortium, through its authorized signatory. The parties never intended that one of the members of the consortium separately invoke the arbitration agreement. Unlike the decision in Automaton Technologies, where there was no contrary intention expressed by the agreement, in the present case, agreement in question clearly envisages the consortium acting through the lead member, because that was the condition there. Then, my lord, if your lordship sees paragraph 30, in response to a query as to why, when the consortium SPV could itself come forward to file the above petition under section 11(6) of the Act, it could not come forward to file the arbitration petition. Mr. Singh stated that Gammon India was not coming forward to do so. This answer is not very convincing. Mr. Singh himself has filed OMPIL such and such on behalf of the SPV, which is also on board today. And, my lord, ultimately, with this, my lord, the section 11 was dismissed. Now, my lord, here the question was that, my lord, the consortium contract specifically empowered the lead member, my lord, to do certain acts. The lead member, my lord, did not come forward. Another member came forward, and here the court said that when there's an agreement, because the agreement itself is the empowering provision, in that case, it could have been done by that person and by no one else. Now, my lord, this, my lord, was further developed because this is a 2016 judgment. My lord, this, my lord, found further amplification, my lord, in a Bombay High Court judgment in the case of, my lord, Maharashtra State Electricity Distribution Company. My lord, may I just hand up, my lord, that judgment to your lordship? My lord, this is reported in 2019, SCC Online Bombay 3920. Okay. Again, my lord, can I have all of that? But my, again, Manupatra, it might not match. My lord, please see, my lord, paragraph 2, first page. On or about 10 September 2008, the petitioner had invited bids for various tenders on zone-wise, circle-wise basis for various works. Pursuant to the said invitation of bid, the respondent, as a lead partner in joint venture with Electropath Services India Private Limited, submitted its offer along with the requisite supporting documents documents on such and such. On 11th October, the respondent and the said Electropath entered into a joint venture agreement on the terms and conditions recorded therein. On 13th October, the respondent and the said Electropath executed memorandum of understanding, etc. Then, my lord, the next paragraph, the dispute arose between the parties on 25th July 2017. Respondent invoked the arbitration agreement. Well, thereafter, if your lordship will kindly have a look at, well, at paragraph 7, paragraph 6. Paragraph 6. It was contended by the petitioner in the said paragraph that the claim was admittedly filed by the lead partner, that is Godrej and Boyce Manufacturing Limited, and thus the said claim was liable to be dismissed with costs on the sole ground for non-joinder of parties, that is Electropath Services Private Limited. It was contended in the said paragraph that the reliefs claimed in the said statement of claim and amended statement of claim were not maintainable, as the claims were not filed by the joint venture company, with whom the letter of award and the contract had been executed. Then on 27th November 2018, the learned arbitrator, in the minutes of meeting, referred to the said issue of maintainability of the claim by the respondent raised in paragraph 5 of the additional statement of defense, and recorded that issue regarding the presence of the said Electropath Services Private Limited will be considered after the respondent files replication to the additional statement of defense. On 22nd December, the respondent filed its application to the additional statement of defense. The petitioner filed an application before the learned arbitrator under section 31(6), praying for rejection of the reference filed by the respondent on the ground that there was no privity of contract between the petitioner and the respondent. Then your lordship will please have a look at, skip over, my lord, quite a few paragraphs, and then my lord will have a look at paragraph 51. Well, this is, my lord, where the discussion on section 19(2) starts. Well, at paragraph 51, without prejudice to the submissions of the petitioner that the claim was not filed by the respondent on behalf of joint venture, it is submitted by the learned senior counsel for the petitioner that under section 19(2) of the Indian Partnership Act, for filing the arbitration proceedings, an express authority from the other partners is mandatory. No such express authority has been obtained by the respondent from its partner Electropath Services India Private Limited before filing the statement of claim, before the learned arbitrator, or even before invoking the arbitration agreement. The statement of claim filed by the respondent does not refer to any pending litigation. He submits that there is a difference between receiving payment on behalf of someone and litigation filed on behalf of the joint venture. The consequences of both these expressions are different. He submits that since for filing arbitration proceedings an express authority of the other partner was required under section 19(2) of the Indian Partnership Act, the respondent cannot rely upon any implied authority to file the said statement of claim. Though it is the case of the respondent across the bar that there was express authority given by its partner Electropath Services Limited to file the statement of claim on behalf of the joint venture, no such express authority has been produced before this court. Learned counsel placed reliance on section 19(2)(a) of the Indian Partnership Act and would submit that the implied authority of partner, in the absence of any usage or custom or trade to the contrary, does not empower him to submit a dispute relating to the business of the firm to arbitration. There is no consent placed on record on behalf of other partner by the respondent before filing statement of claim. The litigation between the respondent and the said Electropath Services India Private Limited is pending today. There is no consent given by Electropath Services Private Limited allowing the respondent to invoke arbitration agreement or even today to prosecute the claim already filed by the respondent on behalf of Electropath Services Private Limited. Then if your lordship will now, well, let kindly come to the reasons and conclusions. That starts, I think, from paragraph 60. And will it straight away, will it come to paragraph 71. I shall now consider as to whether the arbitration agreement that was invoked by the respondent was invoked on behalf of the joint venture or individually. A perusal of the notices issued by the respondent invoking the arbitration agreement indicates that in the said notices addressed by the respondent for appointment of the arbitrator was issued by the respondent by referring to various contracts entered into between the petitioner and the joint venture. The petitioner contended that according to clause 20.4 of the contract relating to the arbitration, the respondent was required to demand in writing the reference to arbitration within 180 days of the making claim before the chief engineer. Since the said condition itself was not complied with by the respondent, the petitioner refused to appoint any arbitrator. The respondent thereafter filed application for appointment of arbitrator under section 11(6) of the Arbitration Act before this court. The petitioner and the respondent executed a joint memo of 21st March 2018. A perusal of the said joint memo indicates that there was a reference to 8 arbitration invocation notices dated 21st September 2017 under 8 tenders awarded to the joint venture. Paragraph 3 of the joint memo provided that in view of the identity of issues under those 8 arbitration agreements to save costs and to avoid possibility of contrary findings or views on identical issues, the petitioner and the respondent in the said application under section 11 of the Arbitration Act agreed and mutually consented to have all the disputes forming the subject matter of 8 agreements to be treated as single composite reference, etc., etc. Then, for your lordship will see paragraph 76. Be that as it may, the said joint memo does not state that the respondent was granted any express authority by its partner. Well, this is important. Be that as it may, the said joint memo does not state that the respondent was granted any express authority by its partner Electropath Services Limited to refer the dispute to arbitration under the said joint venture agreement or under the agreement entered into between the petitioner with the joint venture. Various claims made by the respondent under the said statement of claim were not relating to payment allegedly due only to the respondent, but it pertains to the joint venture of the respondent with Electropath Services Private Limited and allegedly payable by the petitioner. There is no dispute that the petitioner did not raise any objection in the statement of defense initially filed by the petitioner regarding the said statement of claim filed by the respondent without impleading the said Electropath Services Private Limited. The respondent had applied for amendment of the said statement of claim thereafter. In the additional statement of defense dated such and such, and more particularly in paragraph 5, it was contended by the petitioner that except contract number such and such, rest of the contract agreements were issued to the respondent with the joint venture Electropath Services India Private Limited as joint partner. The letter of award was allotted to the joint venture party. The contract agreement was also executed with the joint venture partner as lead partner. Well, then if your lordship will kindly come to paragraph 96. In my view, even otherwise, this court in the said judgment did not consider the effect of section 19(2)(a) of the Indian Partnership Act 1932, and more particularly that in the absence of an usage or custom of trade to the contrary, implied authority of a partner does not empower him to submit a dispute relating to the business of the firm to arbitration. The judgment of this court in the case of Oil and Natural Gas Corporation is thus clearly distinguishable in the facts and circumstances of this case. Reliance placed by the respondent as well as by the learned arbitrator on the said judgment is totally misplaced. Mr. Calcutta, learned senior counsel for the respondent, did not dispute that the provisions of the Indian Partnership Act 1932 would apply to the joint venture agreement between the respondent and the said Electropath Services Private Limited. The only argument advanced by the learned senior counsel is that the respondent had express authority from the said Electropath Services India Private Limited recorded in the joint venture agreement and the power of attorney executed by the said Electropath Services Private Limited in favor of the respondent to file claim on behalf of the joint venture. The emphasis is laid on clause of the joint venture that the respondent alone would be entitled to incur the liability and to recover the dues of the joint venture from the petitioner, which according to the learned senior counsel would include the right to invoke arbitration agreement and to file recovery proceedings for the recovery of the claims on behalf of joint venture. The judgments of the Supreme Court in the case of New Horizons, in the case of Gammon India Limited, and the judgment of the Andhra Pradesh High Court in the case of GVR, MPL, etc., would assist the case of the petition on the concept of joint venture. In my view, there is no merit in the submission of Mr. Calcutta, learned senior counsel for the respondent, that the said Electropath Services Private Limited was not a necessary party to the statement of claim, on the ground that the said Electropath Services India Private Limited had allegedly given an express authority to the respondent to recover dues of the joint venture from the petitioner in the said agreement. Section 19 of the Indian Partnership Act 1932 deals with the implied authority of the partner as an agent of the firm, subject to the provisions of Section 22. Section 19(2) of the Indian Partnership Act provides that in absence of any usage or custom to or trade to the contrary, the implied authority of a partner does not empower him to submit a dispute to the business of the firm to arbitration. It is thus clear that the express authority of a partner is mandatory for submitting a dispute relating to the business of firm to arbitration. The respondent has not placed reliance on any authority given by the said Electropath Services India Private Limited, authorizing the respondent to submit the dispute relating to the business of the joint venture against the petitioner to arbitration, as contemplated under Section 19(2)(a) of the Indian Partnership Act 1932. The respondent could not invoke any alleged implied authority to sue the petitioner and submit the dispute relating to the joint venture to arbitration. The so-called express authority relied upon by the respondent in the joint venture agreement, as well as the power of attorney, does not empower the respondent to refer the dispute relating to the joint venture to arbitration. During the course of argument, the counsel court suggested to the learned, this is very important. During the course of argument, the court suggested to the learned senior counsel for the respondent whether any express authority or by way of NOC can be obtained from Electropath Services Private Limited to permit the respondent to continue the arbitral proceeding filed by the respondent as if filed on behalf of the joint venture and the said Electropath Services Private Limited would be bound by the outcome of the arbitral proceedings. The respondent, though filed an affidavit before the court on 1st October, did not rely on any express authority. And then, my lord, the court goes on to hold that, my lord, accordingly, my lord, it is barred by reason of the provisions of Section 19(2). Now, my lord, this decision of the Bombay High Court, my lord, is quite similar on facts of our case. And, my lord, then we have, my lord, a later decision of the Delhi High Court also. My lord, this is, my lord, in the case of consulting engineers. On the other. Please have a look at paragraph 15 first. On the other hand, learned counsel appearing for the respondent submits that the present petition is not maintainable and is liable to be dismissed, as there is no valid and existing arbitration clause between the petitioner and its individual capacity in the respondent. The consultancy agreement dated such and such was executed between the respondent and joint venture ACOM in association with the petitioner. In the consultancy agreement, the joint venture consortium is referred to as the consultants. Admittedly, the present petition has not been filed by ACOM and or with the specific authorization or consent of ACOM. Thus, it is contended that the terms of the MOU do not confer any express or implied authority on the petitioner to pursue the contractual matters, which include invocation of dispute resolution clause for raising any dispute in individual capacity without the participation or approval or authorization or consent of the lead member, that is ACOM. In support of its submissions, the respondent has relied on the following judgments, Geo Miller and Maharashtra State Electricity, which I have showed your lordship. Then after that, your lordship will kindly skip over and come to paragraph 20. For participating in the present tender process, in order to provide consultancy service to the respondent, petitioner entered into MOU dated such and such with ACOM. As per the said MOU, petitioner formed a consortium with ACOM in order to provide services to the respondent authority. Then, my lord, clauses of the MOU are set out. I will not trouble your lordship with that. Then paragraph 21. Thus, the petitioner participated in the tender process as joint venture after entering into MOU with ACOM, by which a consortium was formed between the petitioner and ACOM. Then kindly come to paragraph 31. Thus, in view of the aforesaid, it is seen that only the consultant, that is ACOM, in association with the petitioner can invoke the disputes resolution clause. It is the consultants and not the petitioner in his individual capacity who are referred to as parties in the arbitration agreement, as contained in the consultancy agreement. Petitioner, not being a party to the arbitration agreement in its individual capacity, cannot take recourse to the arbitration clause in its individual capacity to approach this court in individual capacity. Then my lord Geo Miller is
33, para 33 and then the end.
yes, my lord. Paragraph 33, then paragraph 34. And my lord, ultimately, my lord, if your lordship sees, my lord, paragraphs 28 notices New Horizon, the concept of person. And my lord, then Maharashtra State Electricity is referred to. And my lord, ultimately, the conclusion, paragraph 37. The petition is not maintainable. Well, I'll not, my lord, multiply judgments. There are, my lord, other judgments of, my lord, some other high courts also. But, my lord, these judgments, my lord, of Geo Miller was followed by, my lord, Bombay and then the Delhi High Courts. And, my lord, these are instructive. Now, my lord, it is with this case that we went before the tribunal. Tribunal said, we'll decide this matter finally. Section 16.2 is not the appropriate stage. Now, my lord, there were two things. My lord, there's also, my lord, a separate aspect. But at that point of time, my lord, we did not know that Devi Markham had gone into liquidation. My lord, member of the consortium, my lord, this, my lord, fact ought to have been brought to the notice, because if Devi Markham is in liquidation, then naturally, my lord, its consent could not have been obtained. My lord, there is the aspect of, my lord, suppression and fraud so far as that is concerned, but my lord, let me come to that later. Now, well, if your lordship will please take up the award. Well, the award your lordship will find is a part of the execution petition. It's in volume 1 of the execution, my lord, execution case, EC, well, which your lordship is hearing along with the section 47. Well, at page 60, I think. Page number 7. Well, this is the first annexure to the my lord, affidavit in support of the honor. Page. Well, this should be, my lord, page number 60, I think. The page numbers are cut off here. I just tell you that. I'm trying to give you.
What, page 35?
I'm grateful, man. Well, but my lord, your lordship may, my lord, ignore most of these pages, because I, my lord, don't want to trouble your lordship with any discussion before paragraph 48. 48, my lord, is where I want to take your lordship. My lord, paragraph 48 is at page 100 and 102.
স্ক্যানে দেখবেন ইন্টারনাল পেজ পরের দিকে কেটে গেছে
হ্যাঁ এটা কেটে গেছে the page number is 145.
The award is in a separate.
Well, the award internal page of the award, well, is at bottom of page is 145 of 364.
Your internal paragraph?
Well, 48.
दूसरा volume देना.
183. 145.
No, internal page. Internal page is 140.
Yes, 180.
Well, this I'll read a little slowly, my lord, because this is, my lord, where, my lord, this objection is dealt with by the tribunal. There is no dispute that IVRCL, one of the members of the claimant consortium as well as the leading member thereof, went into liquidation, and a liquidator is appointed to run IVRCL as a going concern. It is admitted fact that prior to such going into liquidation, the claimant consortium, of which IVRCL is the lead member, already got the job in question from the respondent, and in terms of the agreement between the claimant and the respondent, IVRCL was the lead member. Respondent was quite aware of the fact of liquidation of IVRCL, and it has also extended the time for completion of the job by 20 months and 20 days on the basis of prayer of the liquidator of IVRCL, the lead member. Well, up to this, well, no problem. Then, moreover, the liquidator has permitted IVRCL to institute and defend the present claim application and the counterclaim respectively on behalf of the consortium. Well, this he could not have done. Moreover, the liquidator has permitted the IVRCL to institute and defend the present claim application and the counterclaim respectively on behalf of the consortium as the lead member thereof in exercise of power under 35(1)(k) of the code. Well, 35(1)(k) of the code means 35(1)(k) of the insolvency bankruptcy code. Well, so far as that code is concerned, well, I don't need to take your lordship through that. That code, well, empowers the liquidator to act for the company of which he is the liquidator, not beyond that, not for a consortium. I should show your lordship that clause nonetheless. Thus, at present, with the consent of the liquidator, the claimant is proceeding with the claim and defending the counterclaim. In the statement of claim, IVRCL has described as lead member along with other 3 members of the claimant consortium who are in no way affected by the order of liquidation. Thus, the factual position that emerges out is that out of the 4 members of the consortium, 1, the lead member has gone into liquidation, and the said lead member is now represented by the liquidator appointed by the concert tribunal, and the other 3 members, although acting on their own and not through the liquidator, are parties to the arbitration. Now, let's pause here for a moment and try to understand what the tribunal is saying. Well, the tribunal says that, my lord, the liquidator has authorized, my lord, IVRCL to file a counterclaim or claim on behalf of all the members of the consortium. The liquidator never had the authority to do that. Secondly, my lord, the tribunal veers off from that question and again goes to say, thus the factual position that emerges out of this is out of the 4 members of the consortium, 1, the lead member has gone into liquidation, and the said lead member is now represented by the liquidator appointed by the tribunal. Up to here, no confusion. And the other 3 members, acting on their own and not through the liquidator, are parties to the arbitration. Where? There is only one claimant, and that is the consortium. The others have not, my lord, participated individually or, my lord, through the consortium, nothing. And, my lord, I should show your lordship that at this point of time, Devi Markham was already in liquidation. That fact was not brought to the tribunal's notice. But, my lord, then, there is also no dispute that Sri Arshi Srimali is an employee of IVRCL and acting as consultant mining project. Head thereof as it appears from the resolution of 3rd March 2022 taken by Shutanu Sinha, the liquidator of IVRCL, authorizing Sri Srimali to sign and present vakalat, claim statement, rejoinder, reply, counter affidavit, interlocutory, miscellaneous petitions as may be necessary on behalf of the consortium. Where did the liquidator have the power to authorize Mr. Srimali, an employee of IVRCL, to, my lord, act on behalf of the consortium? Then, my lord, please see. Thus, even if the authorization of the liquidator is taken to be limited to the lead member of the consortium, even if the authorization of the liquidator is taken to be limited to the lead member only, and not to the 3 other members by virtue of the authorization of the liquidator, Sri Srimali was, in my opinion, justified in verifying the pleadings on behalf of the claimant consortium, consisting of four parties. But that's completely contrary to law. And, my lord, not only that, thereafter, he, my lord, goes on to say, my lord, Sri Srimali was, in my opinion, justified in verifying the pleading on behalf of the claimant consortium consisting of 4 companies, including IVRCL, because he has, by virtue of his authority received from the liquidator, come within the purview of by one of the parties pleading or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. And then, my lord, the tribunal refers to Order 6, Rule 14 of the Code of Civil Procedure with the greatest of respect. My lord, this, my lord, ultimately, my lord, seems to, my lord, completely overwhelm Section 19, subsection 2. Now, my lord, thereafter, my lord, your lordship will find, my lord, very detailed descriptions to, my lord, Order 30 of the Civil Procedure Code, everything. But, my lord, Section 92 is, my lord, swept under the carpet. Well, I'll, my lord, take some more time, my lord. This, my lord, is a
more time.
This, my lord, this, I have to place this award, my lord. I can, my lord, continue, but, my lord, I think, my lord, I can continue, my lord. There's no difficulty, but, my lord, I'll take a little more time. But because there's also the aspect of fraud, because this, my lord, aspect is clearly, your lordship will find that, well, a tribunal says that he is acting on the authority of the liquidator. Liquidator had no business or, my lord, no right.
So has he dealt with this this proposition in anywhere else in the award?
Well, so far as this proposition is concerned, my lord, completely ignored. Well, I'll show your lordship.
as far as 19.2 is concerned.
No, I show your lordship. My lord, 19.2 is, my lord, overwhelmed. 19.2 seems as if, my lord, it's completely
No,
insignificant.
but then we are only looking at something which is goes to the root of the.
That's right. We are looking at 19.2 and nothing beyond that.
Stopped at 19.2. That's why 49 it deals with.
Yes.
No, I should place your lordship. My lord. Kindly, my lord, allow me to carry on.
49.
Arey, porchi, sorry, I'll read everything. Don't worry.
Yes.
Now, my lord, this is where he says, now, my lord, please see para 49.
Yes.
Mr. Shah, in his contention, referred to section 19.2 of the Partnership Act in support of his contention that the position of the consortium being similar to a partnership, one of the partners is not authorized to refer dispute to arbitrate an exercise of power implied.
Heard. इसको heard सीधे transfer. Keep it for further hearing on.
Next week.
Next Thursday.
Next Thursday.